Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. My name is Riffat Hussain and I am your host for the next hour. For our regular viewers, you will be aware that this show is designed to answer your legal queries and to provide as much guidance as possible to help you address the issues that you are currently experiencing. You can participate in this show in one of two ways, either by calling directly into the studio on the landline number that you find at the bottom of your screen. Alternatively, if you do not wish to speak to me live on air, then you may send your question through on the WhatsApp number, again at the bottom of your screen. What I ask is that when you do send your question through, please do send as much information possible without identifying individuals so that I can understand the issues that you are asking about and to address them as fully as possible. If it's not possible for me to understand your query, then I may provide some general advice, or I may ask you to send some follow-up questions so that I may deal with them for you. Any questions that you do send through must relate to English and Welsh law, as that is the jurisdiction that I practice in. And I do get a lot of queries about individuals who wish to participate in the show but have limited command of English language. Please feel free to type your question in the Urdu language, or if you do want to present your question in the Urdu language live on air, then please do come through and I will be able to take that for you. For our viewers who speak other languages, unfortunately, I'm not that talented, but I will do my best to understand your query in English. You may want to use Google Translate if you find it more convenient, or any other translation application available to you to send your question through in English. One of the most popular topics and fields of law is immigration law. We do receive a lot of questions, and it is a field that I specialise in. I am, however, able to answer questions in other fields. So if you do find yourself facing an employment issue, for example, or an issue with regards to criminal matters or civil litigation, family matters, then please do come through with those. With regards to any family law issues, please be aware that there are directions from family courts which prevent you from discussing proceedings and identifying individuals. So always be aware of any directions and restrictions in regards to proceedings, and particularly ongoing proceedings. Just be cautious. We do not want to be in contempt of court, and certainly do not wish to be breaching any orders, because that can be a very serious matter. Moving on to some of the queries, and these queries do start coming in quite thick and fast, and I often do run out of time. So please do get in there as early as possible if you do want to receive an answer to your question. It may also be helpful to our viewers to listen to the question prior to theirs, as I may have already answered your query, and it then gives somebody else an opportunity to present a different matter and to help others understand the situation and their legal rights around that. The first topic that I have received a number of queries on relates to the delays, and this has been a theme in the last few shows that I have done with regards to applications being delayed, both in country and out of country. And as always, the advice, unfortunately, at the moment is you need to wait. If the delay becomes excessive or disproportionate to your circumstances, then it's a matter that you may seek to challenge legally through a formal complaints process with the Home Office, and also through judicial review proceedings, but do be legally guided with regards to those. There is some disquiet and a significant amount of disquiet around the fact that a lot of out-of-country applications have had their timescale for consideration extended. So we've gone from 12 weeks for processing out-of-country applications to 24 weeks. And that is to prioritise applications from those fleeing the conflict in Ukraine. and a lot of concern around the unfairness of that system. Needless to say, both are being handled badly. The Home Office is not processing out-of-country applications, but they're also not processing in any kind of adequate way the applications from those fleeing Ukraine. And so the backlog is forever increasing. Again, the same complaints process, if you are able to demonstrate that your circumstances are different, and for some reason that there are compelling circumstances which require your application to be expedited and considered out of order, then do present that to the Home Office and do put that information through. But I can only, unfortunately, advise about what the current rules are and how you may seek to challenge those. It's not really within my remit to discuss the fairness or unfairness of that system. There are more qualified people that are addressing those for you. With regards to the issue that I discussed last week as well, I've had a number of queries following on from that, and I did run out of time towards the end of the show with regards to the new family life provisions which come into force later in this month. On the 20th of June, there is new guidance with regards to private and family life applications, and specifically applications relating to children who are born in the United Kingdom, who can then apply for indefinite leave to remain as soon as they turn 7 years of age and have resided in the UK for that period. The questions again relate to how those applications can be made, what kind of evidence is required to support those. I did discuss this previously in March, and again, as I say briefly, last week. In terms of supporting evidence, one would need to demonstrate the child was born in the United Kingdom. So the natural way to do that is to produce a birth certificate which confirms the date of birth, and it also confirms the place of birth. Moving on from that, an applicant will need to demonstrate that this child, or the child applicant will need to demonstrate that they have been in the United Kingdom for a period of 7 years. And again, look at what kind of evidence, documentary evidence from official sources can be provided to satisfy the Home Office that the child has not left. The absence of evidence can also be helpful. So if the child, for example, has never held a passport, then it's unlikely that they have left the United Kingdom because they can't travel without a passport. But don't simply rely on that absence. Do produce positive evidence of presence also. For a young child, so certainly for the first few years of the child's life, you will have the Red Book and the health workers' records to indicate that the child was present. You'll have the immunisation records from the GP. Furthermore, you will also then have nursery records, and then school reports and records on that basis, any hospital appointments, any doctor's appointment letters. All of these indicate that the child has been present in the United Kingdom and is therefore integrated within UK society and should therefore remain within the United Kingdom. So that's how you would demonstrate. It's the same evidence that you would use currently to make those applications. The difference is in the outcome. So from the 20th of June, any application submitted thereafter, a child applicant who falls within this category will be granted indefinite leave to remain, whereas if you made the application today or prior to the 20th of June, then that child will then go on to the 10-year route to settlement. So I hope that does clarify that situation for you as well. Now, with regards to another question, and this relates again, it's connected with these child applications based on children and the private and family life with children in the United Kingdom. So that there is quite a significant overlap sometimes with family law and immigration law. Sometimes we have applicants who have children who have either resided in the United Kingdom for a period of 7 years and known under the immigration rules then as a qualifying child, or children who are British because a parent was British when that child was born. But the marriage has broken down and the parents are no longer in a marital relationship, although they are both involved in the children's lives. In those circumstances, what we often find, particularly where those relationships have broken down acrimoniously, is that the parent who is not residing with the children, often the father, is wanting contact with his children. And because of the relationship status, a mum and family are resisting and not allowing that contact. And inevitably, dad is then left to knock on the doors of the family courts for access and contact orders. The one thing to be wary about is, firstly, do seek legal advice from a family practitioner about the consequences of making these applications. Increasingly, some family law judges are seeing these applicants as trying to manipulate the legal system for their own immigration purposes. And so what will be the consequences if your application is refused by a family law judge? Do consider that before making the application. They're not as straightforward as many are led to believe. Secondly, if an order is granted, you are not permitted to disclose that to anybody without the permission of the family court and the family judge. And this is hugely important that you are aware of this, that there can be huge implications, not only for the individual who is disclosing these reports, but those who assist them. We are going to a brief break. On the other side of this break, I will continue to discuss the consequences of submitting those reports. Join me then. Assalamu alaikum. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Before we went into the break, I was just discussing the implications of disclosing family law court orders without the express consent of the family court judge. And the consequences can be quite serious, both for the individuals concerned, but also for the legal representatives concerned. And if there is not the correct permission in place, then it is a criminal offence and contempt of court. And people can be prosecuted and have been known to be prosecuted for those. So just because an order has been made does not mean that that can be disclosed. And again, please do seek advice in relation to that. If there are family law proceedings, you have a court order and you are seeking to rely on it, discuss that with your solicitor, but be absolutely sure that you are abiding by the restrictions placed on you by the family court judge not to disclose this without the prior consent. Again, my experience is that generally the family courts do grant permission, particularly where the permission is required to disclose in relation to immigration applications, and certainly for immigration appeals where the family court is disclosing to another judge, an immigration judge in that case. But do not fall foul, because far too many people are starting to fall foul of those restrictions. So I hope that does help. We do have a question, quite an interesting question, and not an immigration law related question. So this question is, I have a friend that had a cycling accident a few days ago. Long story short, the other cyclist involved was riding down the wrong lane, unfortunately ending up colliding with my friend. My friend came out of it a lot worse than the guy who caused the accident, and is having to take a substantial amount of time off work due to this. Is there anything at all that we could potentially do to hold the other party at fault for this, thank you for your time. It's my absolute pleasure, and that's what I'm here for. So with regards to this accident, it's a classic personal injury type scenario. Somebody has, through their actions, caused significant injury to another individual, in this case our questioner. And that the fault here, based on the information I have in this question, is that the person who collided with the injured party was riding their bike on the wrong side of the road. In those circumstances, they could be liable for the injuries that they've caused and the ensuing losses as a consequence. So loss of earnings, if there's any other losses that arise from that. So the best course of action is to seek legal advice with regards to that personal injury claim. You do need to identify who the other cyclist was, and I'm assuming that you either know or are able to ascertain who this individual was. A lot of companies now do offer initial free legal advice. It may just be the first 10 or 15 minutes. And a lot of companies in this sector do offer the no-win, no-fee option. And that's always helpful because it gives you a good indication of whether a company expects your case to be successful or not. A company will not take your case on a no-win, no-fee basis if they believe you are going to lose. And so there must be good chances of you winning if they agree to do that. The only word of caution that I will throw to the wind here is do read the small print. What will you be paying if you do win? And are you prepared to pay that? And are there any other charges? What happens if you do lose? Are there still some charges or are there not any charges? So always understand what your legal obligations are when you enter such agreements. The time limit is 3 years, so you do need to bring a claim within 3 years of the accident occurring. This was only a couple of days ago, so there's still plenty of time. But these things are best done when the circumstances arise. The longer you leave it, the more difficult they get. People move on, memories fade, evidence erodes, and it's a lot more difficult to do that. Whereas if you strike whilst the iron is hot, then you're more likely to get the correct evidence. You're more likely to be able to contact the individual concerned. You're more likely to be able to get this progressing at the earlier stages. So I hope that does help you. But personal injury is what you're looking for. Write down, and I will do so sooner rather than later, exactly what happened. The sequence of events. Things that you do need to consider are, you say that the individual was on the wrong side of the road. Sometimes with these kind of claims, it helps to have either an illustration or even photographs of the area so that the person considering the claim can actually see where the accident took place and makes more sense of what you're describing. Describe the weather, and this is why contemporaneous notes are important, because again, as I said, memories fade over time. What time of day was it? Was it light? Was it dark? Were there other individuals? Is there a potential for witnesses? There's different factors that would then determine, were there any obstructions? Because if there were obstructions, is somebody else also liable? So, for example, you mentioned that this cyclist was on the wrong side of the road. Were they on the wrong side of the road because their side of the road was blocked by a vehicle, for instance? Or were they just on the wrong side of the road? So there are a number of factors. If they were on the wrong side of the road and they were so because a vehicle was blocking their path or something else was blocking their path, then, as I say, you may have another person or even a company liable or contributing to the liability because they forced the cyclist who then went into you to take that action. So a number of factors, but do try and write down as much as you're able to, because it does help in the long run, and it preserves your memory, and that's likely to be clearer now than it will be in 3 weeks or 3 months or even three years. So I hope that does provide you with some assistance in how to proceed. If I have missed anything, then please feel free to send through a follow-up question. So that's the personal injury side, and thank you for sending that question through, because it helps, and it's always nice to have that variety. We do have a lot of issues with access to legal justice at the moment. It is quite difficult to find lawyers, to afford to pay lawyers. And that's something else that I would probably touch on at this point. There is a myth that lawyers are very expensive. That's not always true. And certainly in a lot of fields now, what you will find is that lawyers through the Solicitors Regulation Authority have transparency arrangements. And what that means is that they are obliged to provide certain details on their public domain. So it may be a website, it may be social media, it may be both. But where solicitors have a website, they are required to provide a certain information to be widely accessible by the public. Certainly in certain fields, including immigration, for solicitors, they are then required to set out their price transparency, so their charges, how those charges are calculated, whether they're hourly rates or on a fixed fee basis. A complaints policy is another requirement for the public to access. And you will find that if you do look at these websites, that you are not probably going to be paying as much as you think that you might be paying. And also compare the price that you are going to pay with the benefit that you derive from that. I see a lot of cases in private practice at the moment where individuals say, well, I've seen somebody on Facebook and I can do this application myself. Well, that may be so, but the individual on Facebook may not be, and is probably not, a qualified solicitor, and you cannot replace the experience and the knowledge that a qualified individual is able to provide you. And the value that you get from your solicitor is that they will share that expertise. They will go above and beyond what you're asking. If you're asking to make a straightforward application, your solicitor will usually assess whether that is the correct application for you. Or is there a better application? Is there something else that you can do that gives you a better outcome? Is there something that you can do later on that will give you a better outcome, but immediately you need to make that application? There are other applications within applications that can be made. So, for example, there are fee waiver applications. There are exceptional case legal aid funding applications for cases where you genuinely cannot afford to pay the fees, but you won't know that until you do access that legal advice. And there is a maxim that says, you know, if you don't use it, you lose it. And that's unfortunately where a lot of the legal services are going at the moment. You find more and more DIY guides or social media groups. And these are individuals who have either gone through an experience themselves and can give you information about that experience, or they've done a little bit of reading and can share that. And then you've got a collective. It works for some. For the majority, unfortunately, it doesn't. And then what we as solicitors see is then those people coming back for us to sort out the mess. And the mess can be quite serious. It can have consequences which you can't then fix. So, for example, if you have, and I'll take immigration as an example, if you have been in the United Kingdom for a period of 5 years, you then make an application for an extension, you do that yourself. If that is rejected, you then have to start again. You have lost 5 years of lawful residence in the United Kingdom, which you can't then get back. And that's a consequence. So was the price that your lawyer was charging worth it? Probably, because you're not going to replace the 5 years leave. So do look at the benefit, not just the cost. And there's a reason why lawyers are charging you at that level. We are proceeding to our second break. Please do come back on the other side and I will take some more of your questions. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum, welcome back to the Free Legal Advice Show on British Muslim TV. I am your host Riffat Hussain and we have now entered the penultimate segment of this show. Thank you for continuing to send through your questions. I will immediately move on to answering some of those. The next question I have is an employment law question. So we are, alhamdulillah, getting the variety this evening. So can one be fired for being off work, off for stress at work, long-term illness? And so the short answer to that is yes. An individual can the employment can be terminated for an individual who has been off long-term for sickness and stress. But it's not a simple case of an employer sacking somebody because they are no longer able to do that job. That there has to be procedures, and employers need to be really wary about this. There do need to be procedures in place, and those procedures must be followed and documented to have been followed before an individual can be sacked or released from their employment. Often these procedures are provided to you at the start of your employment. Also, a good place to check is the contract of employment as to what the contract says with regards to sickness. And then you will often find that there will be an office manual or some kind of similar policies, guidance within the office. So do request access to that and check that it has been followed and that you have been consulted with the correct procedure before the employment was terminated. If it was not terminated in accordance with those procedures, then that may give rise to unfair dismissal and a claim for that. But the starting point, check your contract, check the office procedures, check that they have been followed. And for any further advice, contact ACAS, who will be able to provide you with independent advice. That's ACAS, an independent organisation that provides employment advice and mediation, and particularly helpful. And you will also find a lot of guidance, even if you don't want to speak to them. You will find a lot of guidance on their website. But the short answer to that question is yes, unfortunately. The employer is under no obligation to keep that position open for you, particularly where it's going to be long-term illness and the job needs doing, that there may be business needs that require the employer to employ somebody else and to, unfortunately, terminate your employment so that they can do that. So the answer is yes, and I'm sure that wasn't the answer you were looking for. But unfortunately, that is the case. But do look at the procedure side of things, because that is, again, something that can be relevant. Moving on to another question. Some of these are quite long, so do bear with me whilst I go through these. Excuse me. So I've got another employment question here. I will be at 3 months on the 11th of June. Sorry, it will be 3 months since I left my job. I resigned. Is it possible now to seek to take my ex-employers to a tribunal? ACAS and maternity action both advised I should take further action, but I wasn't in a good headspace. So this relates more to time limits. And again, you're well advised to contact both those organisations. You're well advised to contact Maternity Action and also ACAS, because they will guide you through this. They will also be able to contact your employer should you want that for any mediation that can be done to resolve this issue without going to the tribunal. Always remember that litigation and legal action must be the last resort. If you can resolve issues prior to getting to that stage, then it's advisable to do that. And certainly tribunals don't look favourably, and courts don't look favourably on litigants who have jumped straight for that option and haven't tried to resolve these issues prior to getting there. So in terms of timeframes, I understand that it is 3 months minus 1 day from the date that you left the employment, so from the date that you resigned. So do you have a look at that? That there may be options to extend the time frame and ask for that to be accommodated if it's necessary. But do go back to ACAS and see how they advise you to proceed. We do have a brother on the line, so inshallah I will proceed to take that call. Hello, assalamu alaikum. Hello, assalamu alaikum. Hello, assalamu alaikum.
Hello, assalamu alaikum.
Alaikum assalam.
Yeah, welcome. I just want to ask a quick question. Basically, what is, I've got someone, a relative of mine, and obviously he's in Cyprus, and he's married to a European. I think he's filed in his paperwork, so obviously he's got his whatever, I don't know, whatever they call it, the naturalization or whatever it is over there. So from there he's turned around, and I think he filed in, because he's married to her, he's filed in his paperwork to get to the UK. But obviously it's been more than a year and he's still waiting. So every time he's going back, he keeps getting setbacks. So they're still processing it, they're still processing, they're still processing it. So obviously we're still in uncharted territory.
Yeah.
Exactly what is the reality? Is it just a physical delay, or actually is there something more sinister?
So just to make sure, brother, I've understood your question. So your friend is a Cypriot national, is that right?
No, he's basically, he's a Pakistani. He's actually got married in Cyprus.
Okay.
So what happened, because obviously I think he's got married when he was in Cyprus to someone, and obviously the woman was a European, but she's filed in the paperwork obviously to Britain over here, because obviously I don't know if she's got a nationality or whatever it is. So that's been before. I think there was some kind of deadline. He's done that, gone through the process, but he's been waiting for a year now. He said to me that he's been waiting a year and there's no response. He's not getting no positive response back. Okay,
and when he's making the inquiries, they're simply advising him to wait. It is under consideration.
Yeah, they keep saying wait.
Yeah.
It's coming up to a year now.
Yeah, and that's not unusual, unfortunately. I don't think there's anything cynical or anything that he needs to worry about. If they were wanting more evidence, they would have asked for that. That's not to say that he's definitely going to get a positive outcome, but if the Home Office is saying to him, wait, it is under consideration, then I don't think you really need to be concerned that they're lying in any way or concealing anything. It probably just is the fact that there are significant delays at the moment, and it's not uncommon for these types of applications to be taken over a year. What you have to bear in mind is with these various deadlines, particularly under the European regulations and the transitional arrangements, a lot of people rushed to put in those applications quite quickly. And so there was a huge upsurge as those deadlines approached with these types of applications, and the Home Office has just been inundated with that. So yes, so nothing to worry about, not to be concerned that there's something cynical happening. It is just routine at the moment for these types of delays. And with all the other pressures that the Home Office has, unfortunately, these applications keep falling to the bottom of the pile. I would give it another couple of months. If there's still nothing at that point, then maybe pursue the complaints policy that I talked about earlier in the show. And if you're still not satisfied, is your friend legally represented? Point, then maybe pursue the complaints policy that I talked about earlier. So, brother, can you just put your TV on mute, because I can't hear you due to the echo that's coming back to me.
No idea. He's been legally represented unless he must have got some.
Brother, can you just put your TV on?
Okay. Hello?
Yes, I can hear you now. Thank you for muting.
Yeah, you know what, to be honest, I can't accurately, I'm not exactly sure on that if he's been legally represented, unless he must have got some help or some kind of assistance, because obviously he would have had to file in the paperwork or whatever done, so he must have got some kind of legal advice there.
Yes.
So if there's any legal representation, because he did say to me, he goes, normally they do have the offices in Cyprus, but he goes, at the end of the day, no one's unavailable to help him there, because everything has been processed, so they've done everything on their side. So I can't, it will be inaccurate for me to conclude exactly what is correct and what's not correct. But all I know is that this is what he's made. This is exactly what he's addressed to me, and that's the only thing that I can address forward. So
and is his wife in the UK?
I don't know. I think she is probably in the UK, or she's from the European, because I know with the European, before they married, they're allowed to freely travel forward.
Yes.
So if she's from Cyprus, unless she's travelled there, or she's from...
Yeah, I mean, it's probably, I know the application's been submitted, but most legal representatives, and I'm not familiar with the system in Cyprus, but certainly if it was in the United Kingdom, the legal representative would remain engaged until that decision is made. It may be worth just kind of going back to those legal representatives to see if there is anything else that can be done to move that application forward. But as I say, I don't think your friend needs to be worried at this stage, particularly if the Home Office is saying the application is under consideration. They wouldn't lie to him. And so just simply wait and give it a little bit longer. Okay. Thank you very much for your question, brother. Just for our viewers, if you are calling in live into the studio, please do mute your television sets behind you. As you heard with that call, unfortunately, the echo does come back, but there is a delay with the sound going out. So it can be really, really difficult. So if you are calling, please mute the television and speak to me on your telephone rather than speaking to me through the television. And that really does help with that communication. And again, I'm so sorry to hear that this brother's friend is experiencing this. It's a recurring theme, unfortunately, delays and more delays and the impact on people's lives. Inshallah, we can only pray that the system improves and that people are able to kind of get on with their lives and rebuild those. We are proceeding to the final break of this evening's show. Inshallah, if you do have questions or queries, do get them in, so I can address them in the final segment. Join me at that point where I do turn to more of your questions. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum and welcome back to the final segment of the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. We are in the last segment, as I said, so please do send your questions through if you do want them answered this evening. If I do miss any today, then please continue to send them through, and inshallah I will pick them up for the show next week. As always, I'll be back on Monday, inshallah, at 7 p.m. Alternatively, if you have a more urgent and pressing query, then our brother Ilyas Bulbulia will be here with his Free Legal Advice show tomorrow. So tune into that and send your questions through for him. Inshallah, we do have another caller on the line, so I will proceed to take that call. Hello, assalamu alaikum. Assalamu alaikum.
Assalamu alaikum.
Alaikum assalam.
Ji, I need for one question. I applied for my children extension visa. Almost is 6 months now.
Yes.
They didn't reply back. How long we take time?
Yes.
And can roughly tell me how long we taking time is new law?
Okay, so brother, when you say you applied for your children, under what category did you apply for your children?
Just a second extension, 2.5 years.
2.5. So are they on the 10-year route to settlement?
Yeah, that's 10 years route.
Okay, and on what basis is that? You say you applied for the children. Is it the whole family that is on that route, or just the children?
My wife and me, I apply for 1 day service. I get for same day.
Yes.
My card, everything.
Uh-huh.
Rest of family, I apply for like normal fees.
Yes.
I don't have a 1 day service fees. That's it.
Right.
Normal apply.
Yes, I get that. At the moment, brother, these types of applications are taking up to 10, well, the Home Office says up to 10 months. Our experience is between 10 to 12 months. So if you're at 6 months, you're probably about halfway through that waiting period. Is there anything that's, is anything impacted by the fact that the children are waiting?
Reason there I call for there, I give to biometric time, and other immigration officer told me that you have already parents who have a visa. Maybe your children get for visa 3 months, even 3 months.
Yeah. Yeah, I mean,
I didn't get.
Yeah, I think that's difficult, and the difficulty that you have at that stage is that the individuals who take your biometrics are not part of the Home Office. They're an independent commercial partner. They're not immigration officials, and so they're probably working off some old information that they had, and they probably were trying to be helpful. But the reality of the situation at the moment, brother, is that the Home Office is understaffed. You will have heard me talking earlier about the delays because of the Ukraine crisis. There's lots of different factors at the moment that are preventing these applications from going through as quickly as we would like them to go through. So it's not about how straightforward or how complex your application is. It's about how quickly the Home Office can process them with the limited resources that it has. So I would say a good rule of thumb at the moment is 10 to 12 months. And if there's no impact on your family, that children are able to go to school and access the services that they need and continue to do so, then inshallah just wait. If you find that there is something that's impacted because of the delay, then that's something that you can communicate to the Home Office, and they will usually try and expedite your application if that case is made out.
This reason there is my daughter have a wedding there is a December. I already fixed for date, but his passport going to extension for visa there.
Right.
Home Office. Any chance for contact within a Home Office? Maybe he first.
Yeah, forgive me, I didn't quite catch the first part of what you said there. So there's something about your daughter's passport.
Home Office. Any chance for? No, daughter. I fixed for wedding. He's staying with me. He's going to visa extension visa.
Right. Sorry, forgive me, brother. Your television at the back is, I can hear the sound, and I'm struggling to therefore hear what you're saying to me. Can you just put your TV on mute or just switch it off for a moment for me, please?
Yeah.
Thank you.
I can hear the sound.
I fixed for my daughter for wedding date for December this year.
Wedding date.
But, yeah.
Yes.
Home Office keeping for passport and biometric card. Any chance for contact within Home Office?
So, I mean, obviously December at the moment is about 6 months away, and it may be that you do get a decision. Is the wedding taking place overseas?
Yeah, in Pakistan.
In Pakistan.
Yeah.
So you are wanting to travel. What I would suggest in that case is, I mean, the Home Office do advise you not to make arrangements to travel whilst you have these pending applications. But I would maybe give it another couple of months. And if you haven't had a decision, say, by the beginning of September, then maybe, or even the beginning of October, then maybe contact the Home Office at that stage and explain your circumstances. And to see, because I think by that point you will have waited a reasonable amount of time. And the likelihood is that they probably are about to make a decision at that point anyway. So September, October time, if you still haven't heard anything, then at that point contact the Home Office and explain the situation and see if they can make that decision a little bit more speedily than they are doing.
All right.
Okay. Thank you so much, brother, for your question. Thank you. So, right. So, again, we find families struggling with this situation around the uncertainty and the misery the immigration process brings to them. But just on the back of that, do kind of be aware of the delays. Don't book travel. Don't make arrangements on the assumption that something may or may not happen. It's usually better to wait to do that because, again, the consequences can be quite serious. So in this brother's case, he has a wedding and a date fixed for a wedding. Again, they haven't thought as thoroughly as maybe they should have done about what will happen if the rest of the family and the bride doesn't have her visa and her passport back by the time they need to travel for that wedding that they've committed to. Be aware, in terms of the documents. If you ask for your documents back from the Home Office, bar some very exceptional circumstances, the Home Office will cancel and withdraw that application. So again, if you are asking for documents back, look at what the implications of that is. Don't simply request the documents back on the hope that you can have the passport and the Home Office can keep the rest and carry on considering the application. They won't do. They will withdraw the application. There are some compassionate circumstances where the Home Office will not withdraw the application. And usually that's where there is a family bereavement and an individual does need to travel and they need their passport for those purposes for a limited period of time. The Home Office have been known to accommodate those kind of requests. But just be cautious because, again, leaving the United Kingdom whilst your application is pending essentially means that you're withdrawing your application. And so if you have left and the application is withdrawn and your previous leave has already expired, then you will not be permitted to re-enter. And that in itself can cause many problems for individuals as well. Again, this is where I often say, educate yourself about your legal rights. Try and do that through reliable sources. And I know social media can be an amazing resource sometimes, but don't accept everything that you find on social media because it's not always correct. It's not always applicable to all circumstances. So it may have worked for one individual. It doesn't necessarily mean that it's suitable for other circumstances and other individuals. Moving on from that, there's a lot of questions at the moment with regards to business visas and work permits to the United Kingdom, and particularly work permits around care workers and the care industry. Now, this is a category where the Home Office relaxed rules to attract foreign workers into the United Kingdom to meet the shortage in labour in the care industry. And it's done that in two ways. So the care workers and various categories of care workers have been added onto the shortage occupation list. And that means that individuals in the United Kingdom, particularly asylum seekers who are granted permission after a certain period of time, are granted permission to work, but work only within shortage occupations, can access those kind of jobs. Often there's training available, so no prior qualification is needed. Most of these jobs, if not all of these jobs, will require proficiency in the English language, and that's understandable. These are some of the most vulnerable people in our society that a worker will be engaging with. it's a minimum ask that they are then able to communicate with them. So care workers, if you are an asylum seeker with permission to work in a shortage occupation, that is a category you can access. And we do have foreign workers from overseas coming into that category. Work slightly differently because they will then need a company that holds a sponsorship license, who is able to offer sponsorship to those foreign workers. And then the applicant themselves will need to make an application under the skilled worker route, so a two-tier application basis there. But there are, again, companies that are specialising in doing that. And the key requirement, again, as I say, is that you have the English language and at level B1. So that you know, if you haven't got that proficiency, you're not going to get a work permit. And also, you do need to find an employer who is willing to sponsor you. There are huge changes with business immigration. Some coming in some that have already come in force, and some coming in force over the coming months, and I will touch upon those in future shows. For today, we are approaching the end. Thank you so much for taking the time to join me and sending your questions through. Inshallah, I will join you again on Monday at 7 o'clock. Assalamu alaikum wa rahmatullahi wa barakatuh.